a Wikividi Documentaries production. Don't forget to like and subscribe. Enjoy. Ruby Ridge. Ruby Ridge was the site of an 11-day siege near Naples, Idaho, U.S. beginning on August 21, 1992, when Randy Weaver, members of his immediate family, and family friend Kevin Harris resisted agents of the United States Marshals Service and the hostage rescue team of the Federal Bureau of Investigation. Following a Marshals Service reconnoiter of the Weaver property pursuant to a bench warrant for Weaver after his failure to appear on firearms charges, an initial encounter between 6 U.S. Marshals and the Weavers resulted in a shootout and the deaths of Deputy U.S. Marshal William Francis Deegan, age 42, the Weaver's son Samuel, age 14, and Weaver's family dog. In the subsequent siege of the Weaver residence, led by the FBI, Weaver's 43-year-old wife Vicky was killed by FBI sniper fire. All casualties occurred on the first 2 days of the operation. The siege and standoff were ultimately resolved by civilian negotiators, with the surrender and arrest of Kevin Harris on August 30, and the surrender of Randy Weaver and the surviving Weaver children the next day. Randy Weaver and Kevin Harris were subsequently arraigned on a variety of federal criminal charges, including first-degree murder over the death of Deputy U.S. Marshal W.F. Deegan. Harris was acquitted of all charges, and Weaver was subsequently acquitted of all charges except for the original bail condition violation for the arms charges and for having missed his original court date. Fined $10,000 and sentenced to 18 months in prison, he was credited with time served plus an additional 3 months, and was then released. During the federal criminal trial of Weaver and Harris, Weaver's attorney Jerry Spence made accusations of criminal wrongdoing against the agencies involved in the incident, in particular, the FBI, the USMS, the Bureau of Alcohol, Tobacco, and Firearms, and the United States Attorney's Office for Idaho. At the completion of the trial, the Department of Justice's Office of Professional Responsibility formed the Ruby Ridge Task Force to investigate Spence's charges. A redacted HTML version of the RRTF report was publicly released by Lexis Counsel Connect, an information service for attorneys, which raised questions about the conduct and policies of all of the participating agencies. A PDF version of the report was later posted by the Justice Department. Both the Weaver family and Harris brought civil suits against the government over the events of the firefight and siege. The Weavers winning a combined out-of-court settlement in August 1995 of $3.1 million, and Harris being awarded, after persistent appeals, a $380,000 settlement in September 2000. To answer public questions about Ruby Ridge, the Senate Subcommittee on Terrorism, Technology, and Government Information held a total of 14 days of hearings between September 6 and October 19, 1995, and subsequently issued a report calling for reforms in federal law enforcement to prevent a repeat of the losses of life at Ruby Ridge, and to restore public confidence in federal law enforcement. It was noted that the Ruby Ridge incident and the 1993 Waco siege involved many of the same agencies and some of the same personnel. The Boundary County, Idaho prosecutor indicted FBI HRT sniper Lon Hortucci for manslaughter in 1997 before the statute of limitations for this charge could expire. The Idaho v. Hortucci case was moved to federal court, which has jurisdiction over federal agents, where it underwent a sovereign immunity dismissal, a non-bank reversal on appeal of a dismissal, and ultimately, the dropping of charges after a change in the local prosecutor. Development. Randy Weaver, a former Iowa factory worker and U.S. Army combat engineer, moved with his family to northern Idaho during the 1980s so they could homeschool his children and escape what he and his wife Vicky saw as a corrupted world. In 1978, Vicky, the religious leader of the family, began to have recurrent dreams of living on a mountaintop and believed that the apocalypse was imminent. After the birth of their first son, Samuel, the Weavers began selling their belongings and learning how to live without electricity. They bought 20 acres of land on Ruby Ridge in 1983 and began building a cabin. The Weaver property was located in northern Idaho in Boundary County, on a hillside on Ruby Creek opposite Caribou Ridge near Naples. In 1984, Randy Weaver and his neighbor Terry Kinnison had a dispute over a $3,000 land deal. Kinison lost the ensuing lawsuit and was ordered to pay Weaver an additional $2,100 in court costs and damages. Kinison wrote letters to the FBI, Secret Service, and county sheriff alleging Weaver had threatened to kill the Pope, the President, and John V. Evans, governor of Idaho. In January 1985, the FBI and the Secret Service began an investigation over allegations that Randy Weaver had made threats against the president and other government and law enforcement officials. On February 12, Randy and Vicki Weaver were interviewed by 2 FBI agents, 2 Secret Service agents, and the Boundary County Sheriff and his chief investigator. The Secret Service were told that Weaver was a member of the Aryan Nations and that he had a large weapons cache at his residence. Weaver denied the allegations, and no charges were filed. The investigation noted that Weaver associated with Frank Kumnick, who was known to associate with members of the Aryan Nations. Weaver told the investigators that neither he nor Kumnick was a member of the Aryan Nations, and described Kumnick as associated with the Covenant, Sword, and Arm of the Lord. On February 28, 1985, Randy and Vicki Weaver filed an affidavit with the county courthouse alleging that their personal enemies were plotting to provoke the FBI into attacking and killing the Weaver family. On May 6, 1985, Randy and Vicki Weaver sent a letter to President Ronald Reagan claiming that Weaver's enemies may have sent the president a threatening letter under a forged signature. No evidence of a threatening letter surfaced. However, the 1985 letter was cited by the prosecutor in 1992 as overt Act 7 of the Weaver family conspiracy against the federal government. ATF involvement. The Bureau of Alcohol, Tobacco and Firearms first became aware of Weaver in July 1986 when he was introduced to a confidential ATF informant at a meeting at the World Aryan Congress. The informant portrayed himself as a weapons dealer. Weaver had been invited by Frank Kumnick, who was the original target of the ATF investigation. It was Weaver's first attendance. Over the next 3 years, Weaver and the informant met several times. In July 1989, Weaver invited the informant to his home to discuss forming a group to fight the Zionist organized government, referring to the U.S. government. In October 1989, the ATF claimed that Weaver sold the informant 2 sawed-off shotguns, with the overall length of the guns shorter than the legal limits set by federal law. In November 1989, Weaver accused the ATF informant of being a spy for the police. Weaver later wrote he had been warned by Rico V. The informant's handler, Herb Barley, ordered him to have no further contact with Weaver. Eventually, the FBI informant Rico Valentino outdid the ATF informant to Aryan Nations security. In June 1990, an ATF agent, Barley, attempted to use the sawed-off shotgun charge as leverage to get Weaver to act as an informant for his investigation into the Aryan Nations. When Weaver refused to become a snitch, the ATF filed the gun charges in June 1990, also claiming Weaver was a bank robber. With criminal convictions, a federal grand jury later indicted him in December 1990 for making and possessing, but not for selling, illegal weapons. In October 1989, the ATF concluded it would be too dangerous for the arresting agents to arrest Weaver at his property. In January 1991, ATF agents posed as broken-down motorists and arrested Randy Weaver when he and Vicki stopped to assist. Randy Weaver was told of the charges against him, released on bail, and told that his trial would begin on February 19, 1991. On January 22, 1991, the judge in the case notified the attorney Everett Hoffmeister that he would be serving as Weaver's attorney. On that same day, Weaver called the U.S. probation officer Carl Rickens and told him he was instructed to contact him. On that date, Rickens did not have the case file at that time, so he asked Weaver to leave his contact information and Rickens would contact him when he received the paperwork. According to Rickens, Weaver did not give him a telephone number. The defense counsel Hoffmeister sent letters to Weaver on January 19, January 31, and February 5 asking Weaver to contact him to work on his defense within the federal court system. On February 5, the trial date was changed from February 19 to 20 to give participants more travel time following a federal holiday. The court clerk sent a letter to the parties informing them of the date change, but the notice was not sent directly to Weaver, only to his attorney. On February 7, the probation officer sent Weaver a letter indicating that he now had the case file and needed to talk with Weaver. This letter erroneously indicated that Weaver's trial date was set for March 20. On February 8, Hofmeister again attempted to contact Weaver by letter informing him that the trial was to begin on February 20 and that Weaver needed to contact him immediately. Hofmeister also made several calls to individuals who knew Weaver asking them to have Weaver call him. Hofmeister told Judge Harold L. Ryan he did not hear from Weaver before the scheduled court date. When Weaver did not appear in court on February 20, Judge Ryan issued a bench warrant for failure to appear in court. On February 26, Ken Keller, a reporter for the Kootenai Valley Times, telephoned the U.S. Probation Office and asked whether the reason that Weaver did not show in court on February 20 was that the letter sent to him by Rickens had the incorrect date. Upon finding a copy of the letter, the chief probation officer, Terrence Hummel, contacted Judge Ryan's clerk and informed them of the incorrect date in the letter. Hummel also contacted the U.S. Marshals Service and Weaver's attorney informing them of the error. The judge, however, refused to withdraw the bench warrant. The U.S. Marshals Service did agree to put off executing the warrant until after March 20 to see whether Weaver would show up in court on that day. If he were to show up on March 20, the DOJ claimed that all indications that the warrant would have been dropped. Instead of waiting to see whether Weaver would show up on March 20, however, the U.S. Attorney's Office called a grand jury on March 14. The U.S. failed to provide the grand jury with Rickens' letter, and the grand jury issued an indictment for failure to appear. U.S. Marshals Service involvement. When the Weaver case was passed from the ATF to the Marshals Service, no one informed the Marshals of the fact that ATF had attempted to solicit Weaver as an informant. As the law enforcement arm of the federal court, it was the duty of the U.S. Marshals to bring in Randy Weaver, now considered a fugitive. Unlike most federal fugitives, who flee across state lines to avoid arrest, Randy Weaver simply stayed in his remote home, threatening to resist any attempt to take him by force. Weaver was known to have an intense distrust of government, and it is believed that the erroneous Rickens letter increased this sentiment and may have contributed to his reluctance to appear for trial. Weaver was clearly suspicious of what he viewed as inconsistent messages from the government and his own lawyer, and this inconsistency further enforced his belief that there was a conspiracy against him. Weaver came to believe that he would not receive a fair trial if he were to appear in court. His distrust grew further when he was erroneously told by his magistrate that if he lost the trial, he would lose his land, essentially leaving Vicky homeless, and that the government would take away his children. U.S. Marshals Service officers made a series of attempts to have Weaver surrender peacefully, but Weaver refused to leave his cabin. Weaver negotiated with U.S. Marshals Ron Evans, W. Warren Mays, and David Hunt through third parties from March 5 to October 12, 1991. When Assistant U.S. Attorney Ron Howen directed that the negotiations cease, the U.S. Attorney directed that all negotiations would go through Weaver's court-appointed counsel. However, Weaver did not have any contact with the attorney and refused to talk with him. Marshals then began preparing plans to capture Weaver to stand trial on the weapons charges and his failure to appear at the correct trial date. Although marshals stopped the negotiations as ordered, they made other contact. On March 4, 1992, U.S. Marshals Ron Evans and Jack Clough drove to the Weaver property and spoke with Weaver posing as real estate prospects. At a March 27, 1992, USMS HQ meeting, Art Roderick codenamed the operation Northern Exposure. Surveillance teams were dispatched and cameras were set up to record activity at Weaver's residence. Marshals observed that Weaver and his family responded to vehicles and other visitors by taking up armed positions around the cabin until the visitors were recognized. Brought to you by Wikividi Documentaries. Would you like to know more?